Part 2. For if you should ever become the proud possession of the public domain, it would push me somewhat off the wall and drive me damn near insane. I'm so sincerely in love with you that a common law copyright just won't do. You're my number one melody on the bestsellers list of my life. You're my precious, priceless paradise, and I want all rights reserved. I need complete copyright control to the sweet sensations of love deeply rooted in your heart and soul. I want all rights reserved. I'm Danny Queen. Welcome back to Color Me Poetry. We're talking about law. We're talking about copyright law with an attorney, and she's telling us a lot of things about copyright laws and a lot of things that sometimes you all write and ask about copyright law. Welcome back, sister.
Thank you.
Sister Theodora-H.Brown, I'm sorry. We were talking about copyright, and we were talking about different forms of copyright. What about public domain? What does that mean?
Public domain. I'm glad you brought that up, because in your poem you said if my love fell into the public domain, then I lose control, and that's exactly what happens. When it falls into the public domain, you lose control over that particular work, and anybody has the right to use that work without getting your permission or paying you money, which is even more significant than that. Again, when we talked earlier about reserving your rights and you having this bundle of rights as a copyright owner, you have a right to exploit that work commercially. Be it in a book or in a performance, and so it's so important that you don't lose protection on that work.
How would that happen?
Well, for works that were created after 1978, which was the year that the Copyright Act of 1976 went into effect, the work is protected for the life of the author plus 50 years. If it's an anonymous work, then it's protected for 75 years. And so it depends on, again, the type of copyright authorship. If it's a joint work where you have two or more authors collaborating on a particular work, then the copyright duration lasts for the life of the last surviving author plus 50 years. And so chances are, for works that were created after 1978, they have not fallen to the public domain, and therefore whoever wants to use the work has to come to you, get your permission, and then you can exploit that work in any manner in which you choose.
It's interesting that you would say if it's an anonymous work, it's 75 years as opposed to
that's right, because anonymous means you can't identify the person, but once you identify that author, the author's no longer anonymous, then you can actually tack on or attach, the actual basic copyright term to that particular person.
So it doesn't matter if I use an alias or not?
No, it doesn't. It doesn't. You still are entitled to copyright protection for that work. That's right.
But if I use an alias, I could get 75 years instead of
Well, an alias is really not anonymous. Anonymous is when someone actually signs and says anonymous source. And so but if someone uses a work, infringes on your work, then you clearly can come out of the background and file a copyright infringement action against that person, and then that's when your identity becomes revealed. But again, you still have protection for that work.
That's interesting.
One of the other things that you mentioned before we took the break, and that deals with registration. You talked about someone coming to you with a pile of poems and what to do with
what would they do
poems. Well, first of all, registration under the Berne Convention, again, which is this international copyright treaty that the United States signed in 1989, you're not required to register the works. But again, I always recommend to clients that you do, because it gives you certain statutory rights. And the statutory rights essentially means that the copyright law protects you and gives you certain rights when you actually register. Registration is a very simple process. You simply fill out a 2-page application. You pay the $20 application fee per application, and you send in a copy of the work, be it an actual physical piece of paper or a tape or videotape or what have you. So it depends on the type of work that you're registering. And once you register the work, then if someone infringes on your work, then you have a right to file a lawsuit against them and claim these statutory damages, and damages being money, a monetary compensation for using your work. And there are even certain levels of of damages that you're entitled to, depending on the nature of the copyright infringement.
This often happens, and copyright infringement often happens in the music business.
Oh, it happens a lot.
A lot of times.
Sampling, music sampling was a big area where you had a lot of litigation, people using, especially the hip-hop music,
the
rappers.
Hip-hops do that all the time.
You hear, James Brown or the Isley Brothers or what have you in the music, where they were sampling the music. They were putting samples of copyrighted works in their music, and they weren't always getting permission from the authors.
They just did it.
They just did it without permission. But a lot of record companies, realized that this was not a wise or prudent thing to do, and so now they're making sure that they are screening these songs before they're actually released to the public, and making sure that they are securing copyright protection or copyright licenses from the owners before they actually.
In other words, they have to pay.
Absolutely. Again, this is that reservation of rights issue where you have a bundle of rights that you can exploit commercially, and you have the right to do that because again, it's your creativity that went into play to create this work here.
Some of the rappers have sampled James Brown to death.
Well, yeah, but James Brown should be happy now. He should be very happy now because he's been very litigious about that, and he has been getting the money that he's so rightly due.
Yeah, I mean, if you use a portion of another person's work, I mean,
you have to give.
In the beginning, they were just using it.
They were just using it. Yeah, there was this sounds real good. Yeah, and they use it without really any understanding
of what they were doing.
What they were doing, and the fact that they were infringing on someone else's work. Now, there are certain situations where you can actually. And this is really an exception to the copyright bundle of rights that you own, where you can use excerpts of works in your copyrighted work without getting the permission of the author, and that's what we call the fair use doctrine. And there, for instance, if you're doing a research paper or you're writing a newspaper article or you're doing commentary or criticism about a particular copyrighted work, then you may forego having to get permission from the owner to use their works in whatever it is that you're creating. But again, that's just it's an exception to the rule as opposed to being the rule. And copyright fair use is actually, it's a defense to a copyright infringement action. So you're not going to know if the use is fair unless someone sues you, and then you've got to, as the user of or the infringer of that copyrighted work, defend in court saying why you believe your use was fair. There are some guidelines that have been passed around in terms of what is fair, but whenever there's a lawsuit, the court looks at that particular case and determine whether or not you have infringed in that particular situation.
I remember a few years ago during the time, 95, during the time of the Million Man March, I did a poem entitled, long dramatic poem entitled The Million Man March.
Right.
And people loved it, and lots of people bought it. But a friend of mine told me that there were people in office buildings downtown who were Xeroxing copies of my poem and placing it all over the building.
Right.